Great. So welcome everyone, and thank you for joining us for today's webinar titled Understanding the Safe Third Country Agreement and Refugee Claimant Eligibility. My name is Bahar Taheri. I'm the project consultant with the BC Refugee Hub, and I will be guiding us through today's session. I'm joining you from the unceded traditional territory of the Coquitlam First Nation, which lies within the shared territories of the Tsleil-Waututh, Katzie, Musqueam, Cookite, Squamish, and Stolo nations. It's important for me to acknowledge the lands that I'm privileged to live, work, and raise my children on, as a way of showing respect and honoring the Indigenous peoples of these lands. Acknowledgement for me is a simple way of resisting the erasure of Indigenous histories and working towards honoring and inviting the truth. I'd also like to take a moment to thank our funder. ISSBC's BC Refugee Hub would like to gratefully acknowledge the funding for this project from the province of British Columbia through the Ministry of Post-Secondary Education and Future Skills. For those of you who may not be familiar with the BC Refugee Hub, it was established in 2015 by ISS of BC and funded by the province of British Columbia, originally in response to the arrival of Syrian refugee families. Today, our focus is on refugee claimants through the BC Safe Haven funding with the province of British Columbia. We offer a wide range of tools, fact sheets, and training sessions to support the sector and promote services across British Columbia. We also have our BC Safe Haven service directory that is updated regularly. It includes programming details and direct referral contacts. You can find the link on the chat box. I'll just post it in there in just a second. And you can also find it on the BC Refugee Hub. And you can stay connected with us through our weekly updates and monthly e-newsletters. We also collaborate regularly with our partners, including VAST, MapBC, and AMSA. If you have any events, services, or programs you'd like us to feature, please send them our way to refugeehub@issbc.org. I would now like to introduce Kieran Davis, Program Specialist with AMSA.
Thank you, Bahar. I'd like to open us up with a brief land acknowledgement. As a provincial umbrella association, AMSA acknowledges that BC is on the unceded homelands of First Nations who have stewarded this land since time immemorial. We recognize the privilege that we have as settlers on this land and acknowledge that AMSA's operations are in the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations. As an organization, AMSA is committed to creating a safe space for Indigenous voices. The BC Safe Haven program provides direct services to refugee claimants in BC. The BC Safe Haven Resource Network is a collaborative initiative funded by the province of BC to offer capacity building support and training to direct service providers. The Resource Network is a collaboration and partnership focused program. Partner organizations, which you can see on the next slide, play a key role creating resources for direct service providers. Capacity building activities include webinars, fact sheets, many other resources, as well as service directories and a service map with referral information for Safe Haven organizations. We also convene working groups to provide service providers an opportunity to share their trends, challenges, and evolving practices with each other and inform resource network activities. Our mental health activities include in-person and virtual workshops, e-learnings and information sessions, and a phone line for frontline service providers seeking support as they work with vulnerable clients. Language activities include the development of curriculum guidelines and resources on a dedicated website for ease of access, as well as tailored trainings for ELL instructors. And finally, our public support gathering arm is engaged through ACES, AMSA's charitable arm, in partnership with United Way to build community support for refugee claimants through public awareness, donations management, volunteerism, housing donation offers, and other community-based supports. And I'd like to conclude by encouraging you to follow AMSA on social media. We're on LinkedIn, Facebook, and X, formerly Twitter. And please visit our website at www.amsa.org for many resources, e-learnings, and recent reports. Thanks, and back to you, Bahar.
Thank you, Kieran. We're excited to welcome our speakers and topic experts today. Katie Lay, lawyer at the Immigration and Refugee Legal Clinic, and Lisa Bruner, policy analyst consultant with AMSA and research associate at UBC. After Lisa and Katie's presentations, we will have time for a Q&A session. You can post your questions at any time in the chat box or the Q&A box. And with that, I will pass it over to you, Katie.
Thank you so much. So my name is Katie. I'm a staff lawyer at the Immigration and Refugee Legal Clinic, located in Vancouver. And I will be giving you kind of the legal, practical side of the Safe Third Country Agreement today. I am also located in Vancouver, on the unceded territory of the Musqueam, Squamish, and Tsleil-Waututh people. And I think it's always important in immigration spaces to hold space for obviously Indigenous rights. It's their land that we're on. And I think that even though it may seem as though Indigenous rights and migrant rights might be kind of in opposition, I think they really go hand in hand, because ultimately these borders that we're dealing with are colonial constructs, they're fake. And once you kind of approach immigration law with that perspective, a lot of the really weird and horrible policy decisions that people make start to make a lot more sense, because these are tools of control. They don't actually mean anything. In classic lawyer fashion, I just want to start this out with a disclaimer. My presentation is going to be all legal information. There's no legal advice. I'm not able to give legal advice in any questions or anything. And the information in this presentation is current to today. So if anything changes in the next little while, just know that this presentation is true up to today. I will start by giving an overview of the Safe Third Country Agreement and the current refugee claims process. So I'll go over some of the regulations and processes about eligibility, the Safe Third Country Agreement at both official and irregular border crossings, some common issues that people face, and I'll touch on pre-removal risk assessments as well. I'll then hop over to Lisa for her presentation, and I'll finish up with a little practical insight on how to help clients. At a high level, and I imagine most of you already know this, but the Safe Third Country Agreement is an agreement between Canada and the United States that requires refugee claimants to seek protection in the first safe country that they arrive in, so Canada or the US. If you don't make your claim in the first safe country, so for example, if you land in the US and make your claim in Canada, you will be removed back to the United States to make your claim. And this does work both ways. We've seen clients who first arrived in Canada, went to the States, and were removed back to Canada under the Safe Third Country Agreement. So the focus is on claiming refugee status or making your application at the first instance. The legal grounding of the Safe Third Country Agreement is set out in the Immigration and Refugee Protection Act at section 101 sub 1 sub E. If the claimant came directly or indirectly to Canada from a country designated by the regulations, other than a country of their nationality or their former habitual residence. And then in the Immigration and Refugee Protection Regulations, we see that the United States is a country designated by the regulations. What is really, I think, important to note from section 101 sub 1 sub E is that it specifies other than a country of their nationality or their former habitual residence, which means that this act, the Safe Third Country Agreement, does not apply to US citizens or people whose country of former habitual residence is the United States. So making a refugee claim as an American is really, really hard for other reasons, but they are not excluded necessarily under the Safe Third Country Agreement. The Safe Third Country Agreement is pretty harsh, where if you have crossed into Canada from the US or vice versa, unless you meet one of the 4 exemptions, you will be excluded under the Safe Third Country Agreement. And there's a little bit of nuanced stuff that I'll get to later about how you cross into Canada and how that impacts your exclusion under the Safe Third Country Agreement. But for ease of explanation, there are 4 exceptions to the Safe Third Country Agreement if you fall under the Act. The first is having a close family member in Canada who can act as an anchor for you. There is a very specific definition of what a close family member is. It can't just be any family member. It's not an objective, or it's not a subjective assessment of, I think they're a close family member. It is an objective definition. And a person can only be a close family member if they are your spouse, common law partner, legal guardian, child, parent, sibling, grandparent, grandchild, uncle or aunt, nephew or niece. So cousins don't count, and anyone who's more removed than an uncle or an aunt or a grandparent or a nephew or niece. So second cousins, great aunts, those don't qualify. The family member must also be a Canadian citizen or a permanent resident, a protected person, and an eligible refugee claimant who has a refugee claim in process or have a valid work or study permit. So if they are someone who has had an application to the Immigration and Refugee Board that's been rejected or withdrawn or abandoned or terminated, they're not eligible. And the family member must also be at least 18 years old. If you are an unaccompanied minor, you may fall into another exception to the Safe Third Country Agreement. To be an unaccompanied minor, you need to be under 18 years old and not have a parent or legal guardian present in either Canada or the United States. And this looks exclusively at the presence of the parent or legal guardian in either Canada or the US. It doesn't look at status. So if you have a parent who is in the US but is out of status, you're still not eligible under this exception because you have a parent present in one of these 2 countries. The last 2 exceptions are if you hold a valid document for Canada. So if you have a temporary resident visa, so like a work permit, study permit, if you're a permanent resident, if you have a temporary resident permit, or another travel document, so like a refugee travel document, you would meet this exception. An ETA does not meet the requirements. And if you are from a country that is visa exempt for Canada, but requires a visa for the US, you could also fall into this exception. So for this exception, it's pretty easy to prove. You just need to have your document with you. And the last exception is public interest exception. So there's a possible exception for people who have been charged or convicted of an offense that would subject them to the death penalty in the US or a third country and need to claim refugee status in Canada because of this. If a claimant falls within one of these 4 categories, they'll need to provide evidence, as much evidence as possible. So proof that they have an eligible close family member, that can be birth certificates, marriage certificates, messages with the family member, immigration documents. If you have a close family member and are using that exception, having the family member come to the border is something that CBSA recommends. So they can verify your family relationship. If you fall under the valid document exception, of course, having a copy of your valid Canadian document is helpful. And if you're an unaccompanied minor, there are some things that CBSA might do, like search databases or confer with US authorities or look at your travel history and residency. They may even try calling your parents to verify what country they're in. So there are some measures that they'll take to make sure that you actually do qualify. If someone is stateless, they would also be exempted from the Safe Third Country agreement. The Safe Third Country agreement, I kind of alluded to this before, applies to people who enter Canada at Canada-US land border crossing by train or at airports, but only in certain circumstances. So for most people who arrive in Canada by plane, it doesn't apply. The specific circumstances that will exclude someone under the Safe Third Country agreement at an airport are if they have been refused refugee status in the US and are transiting through Canada as part of their deportation. The Safe Third Country agreement also applies at irregular border crossings, so it covers the entirety of the Canadian border. This is relatively new. There is an expansion of the Safe Third Country agreement in 2023 that led to including irregular border crossings. You may have heard before about Roxham Road is one of the really common irregular border crossings that people would use, but that is now encompassed under the Safe Third Country agreement. And if you cross irregularly, you are not eligible to make a claim for refugee protection within 14 days of your entry. So people call this the 14-day loophole. If you have been in Canada for more than 14 days, you can then make your refugee claim. But this leads to its own complications of being able to prove that you have been in Canada for the 14 days. If you cross irregularly and don't meet any of the 4 exceptions and haven't been in Canada for 14 days, you will be turned back to the United States. When a claimant crosses the border and makes the claim at a port of entry, so at like a regular land crossing, they will be assessed for eligibility by the CBSA officers who are there. So providing identification is really important. Your passport, birth certificate, some kind of government issued ID to prove your identity. And then, as I said before, evidence that supports the fact that they meet an exception. And as much evidence as you can provide. So some things that officers might look at are if you have a relative, a close relative in Canada who themselves made an immigration application, they may look at those application forms to see if you were listed as a sibling or if you were listed as a parent or child. They may look at birth certificates to see who's listed as your parent, or look at other family records to confirm that your close family member is actually a close family member. And then I also wanted to touch on pre-removal risk assessments, which are assessments done by CBSA before someone is removed from Canada back to their country of citizenship. It's something that is offered to a claimant, or not a claimant, is offered to a foreign national that they can accept or deny, and is something that is, in a sense, kind of like a paper-based refugee claim with no hearing, and is focused on whether you would have risk of cruel and unusual punishment or torture, risk to life in your country of citizenship. If a prospective claimant is not eligible for refugee protection in Canada because they fall within the Safe Third Country Agreement, they will not be eligible for a PRRA because they're being sent back to the United States, not their country of citizenship, and are being sent back to a safe country. The prospective claimant will be given an exclusion order and will have to leave Canada, but is not being deported or removed back to their home country. And because of this, there is an assumption, a presumption, that the prospective claimant is being removed to a safe country because Canada has decided that the US is a safe country. So no PRRA. But there are some situations where a prospective claimant may be eligible for a PRRA. For instance, there's some situations where a claimant might have entered Canada to make their refugee claim, been sent back to the US under the Safe Third Country Agreement, and then re-entered Canada irregularly. And in that case, the prospective claimant would be issued a deportation order to be removed to their country of citizenship rather than the US, and would be potentially offered a pre-removal risk assessment. It's a bit of a complicated situation, but really the main, I think, important takeaway is that while in many situations, if you are not eligible to make a refugee claim, you may be eligible to make a pre-removal risk assessment. That isn't the case at the first instance with the Safe Third Country Agreement. If you do have any clients in that situation, it would be important for them to get legal advice to assess their specific circumstances. But yeah, I think that's it for me for part one. We'll go to Lisa, and then I'll be back to wrap things up.
Thank you so much, Katie. And thank you everyone for being here today and for inviting me to speak. Katie beautifully walked us through this current Safe Third Country Agreement legal landscape, and I'm going to discuss something different. I'm going to talk about changes that we may soon see as a result of the proposed Bill C-12. If this bill becomes law, it's going to have major implications for refugee claimants, so we can't really talk about the STCA without preparing for the potential impacts of this bill. So I'm joining virtually from the traditional ancestral and unceded territory, the Musqueam people, and I just want to take a moment to share this resource that can stimulate some conversation about settler colonialism among immigrants to Canada, such as myself. This talk is going to focus on a federal bill that's designed by a settler colonial state. So I think echoing what Katie said in her land acknowledgement, it really risks normalizing Canada and its borders as uncontested. But it really needs to be said that underpinning any critiques that we may have of this bill or Canada's refugee claim system in general is this meta critique of Canada's borders, which were created and continue to be justified by violent dispossession. So elsewhere, I've done a full in-depth analysis of this entire bill, and it's really long, it's really complicated. Today, I'm focusing specifically on access to hearings before the Immigration and Refugee Board, or the IRB, which I think all of you know is an independent tribunal designed to adjudicate refugee claims in Canada. I'm going to try to explain what is the government trying to achieve with Bill C-12, why, and what are the potential implications. So, what is the government trying to achieve? To understand Bill C-12, we have to first discuss a different bill called C-2, or the Strong Borders Act, which the government introduced in June. And if you look at the wording that Public Safety Canada used to describe it here on the screen, you can see that the framing was really on keeping Canadians safe by stopping all these nefarious things like organized crime and fentanyl and money laundering, but first and foremost, keeping Canada's borders secure. And a significant point about this bill is that there was an explicit rhetorical linkage between crime and immigration, which is a pretty clear shift from previous federal rhetoric under Trudeau. So Bill C-2 was an omnibus bill, meaning that it tried to amend a lot of different acts across multiple federal departments all at once. And an issue with omnibus bills is that they're so big and they're often quickly pushed through, so it makes it really difficult for parliamentarians to actually understand the issues and their implications. So this particular bill was 140 pages long, and it was immediately controversial, but it was also pretty complicated. So over 300 organizations, such as the Canadian Council for Refugees, spoke out against it. There were at least 4 major coalitions involved in organizing responses, but the critiques of the bill came from a lot of different angles, and it looked very unlikely that it would be passed quickly. So the government decided to chop it up because they really wanted to get certain border protection measures to go through, in their words. So in October, they reintroduced a slimmed down version of the bill called C-12, which only amends the acts here in red. It's still big, there's still a lot of changes, but in this form, the bill became more likely to pass. So there's still active advocacy against Bill C-12 happening, but at this point, every party except for the NDP has essentially indicated its support. So I think, we as a sector should plan as if it may pass, and it's likely to return to the House for final votes in the near future. So there are 3 key immigration changes proposed in C-12. The first is expanded information sharing, which would essentially allow Immigration, Refugee and Citizenship Canada, or IRCC, to more freely share client information internally and with federal and provincial partners. So this could include an individual's identity, their status, or their immigration documentation. The second is expanded powers to manage and cancel immigration applications and documents. So this is very significant. It's currently being discussed. The Conservatives are discussing amendments for various reasons to this particular proposal. But for the purposes of today's discussion, it's really important to note that this power does not include canceling refugee claims within its purview, and that's something that the government has made clear. So the third point is what this presentation is really going to focus on, the essentially an overhaul of the refugee claims system in Canada. And I'm going to specifically focus on those changes which intersect with the Safe Third Country Agreement, or STCA. So the bill sets out 2 new major ineligibility grounds for refugee claims. And that means it's basically blocking specific people from a hearing with the IRB. So the first new ineligibility ground is on this slide. And this would mean that no one can make a refugee claim more than 1 year after their first entry to Canada. So the clock to calculate the first entry would be set retroactively to June 24th, 2020. And this date was selected because it's the date the Canada Border Services Agency fully implemented its exit data collection system. So basically, if you have entered Canada since June 24th, 2020, this is what would count. The ineligibility ground would apply to all claims made on or after June 3rd, 2025, I believe. I have to double check that for Bill C-12, but I believe it's the same in the amended bill. And very importantly, leaving Canada and re-entering would not reset the clock. So the purpose of this ineligibility ground from the government's perspective is to target potential refugee claims made by temporary residents who are already in Canada. So, for example, students or workers. Just to mention that it does go against the basic norms of humanitarian protections. It goes against the UNHCR's recommendation against time limits for submitting refugee applications. Some countries do have time limits, such as the United States, which has a 1-year filing deadline. This has been heavily criticized in the US, and even in the US, it's based on the most recent entry, not the first entry. So this is quite restrictive. The other ineligibility change would be that people would not have access to an IRB hearing if they enter Canada irregularly, meaning between official ports of entry, from the US and do not claim a refugee or make a refugee claim within 14 days. So essentially what this does is pairs with the STCA that Katie discussed to eliminate access to an IRB hearing for most people entering via the US. So this is targeting potential refugee claims made by temporary residents currently in the US. So I'm going to show a general diagram. Please don't consider this legal advice. It's very general and just for kind of illustrative purposes. But as Katie has explained, the current STCA basically prohibits refugee claims by those seeking entry to Canada from the US by land. However, there are some exemptions, does not apply to US citizens, stateless people, et cetera, et cetera. And right now, it does not apply to those who cross between official ports of entry and make their claim 14 days or more after the entry. So Bill C-12 essentially attempts to close this last so-called loophole that those who cross irregularly and remain undetected for 14 days will not be permitted to make a refugee claim to the IRB. What this is doing is essentially like further externalizing Canada's already very isolated borders to prevent as many claims from as possible from reaching the IRB. The difference that this bill would make is that unlike those who are detected within 14 days, people who remain undetected may have the opportunity to apply for a pre-removal risk assessment, or PRRA, as Katie discussed. So I know the Canada-US Border Rights Clinic is working on a resource for practitioners that's going to explain these processes in much more clarity. Hopefully it'll be available in the new year. So given that Bill C-12 is not a law yet, I think what would be useful for this discussion is to have a key takeaway to essentially keep in mind that, as many of you know very well, Canada's refugee claim process is very complicated. And if Bill C-12 passes, it is going to get more complicated. People entering by land may still be incentivized to cross irregularly and remain undetected for 14 days to avoid the STCA. But instead of getting access to a refugee claim through the IRB like they do now, one of two things is likely to happen under Bill C-12. So some people will be offered a PRRA, pre-removal risk assessment. And I think if Bill C-12 passes, all practitioners will become much more familiar with PRRAs because it's going to be a much bigger part of Canada's system. So just a little bit of background about the PRRA that I want to mention. So under international law, countries cannot return people to a country where they face persecution. And PRRAs were originally supposed to be this final check before someone is removed from Canada to ensure that no new conditions have arisen. And it's meant to prevent something called refoulement. But over the years, PRRAs have really become part of this like mission creep in which they function as a quasi-alternate refugee claim system. But it's important to note that they're very different from IRB hearings because there's no right to appeal other than judicial review at federal court, which takes a very long time. There's usually no oral hearing. The decision maker is an IRCC employee as opposed to the IRB. The application is by paper instead of an oral hearing, and the approval rates are pretty low. The other thing is that you can't apply for one unless the CBSA invites you to. So Katie, you can correct. I'm not a lawyer. Katie, if you have any additions or corrections, please jump in at the end. But essentially, people need to wait to be invited to apply. So when a person is offered an opportunity to apply for a PRRA, they normally have 15 days to submit their forms, another limited window to submit written submissions. So, there's a risk that people might miss the notification to apply. It's a very, very different paper-based process usually. The other thing is that some people are not eligible for a PRRA, so there's a second possibility that people may fall into. It's people who are from certain countries who are considered unremovable based on a list. It changes frequently, but this is the current list. And these people are at high risk of falling into a kind of legal limbo, can lead to family separation and this kind of long-term uncertainty because their removal orders are unenforceable but not eligible for a PRRA. Okay, so why these changes. I just want to give a little bit of policy context of what's driving these changes so that we can have a better understanding of what is likely to be happening. Why is the government trying to make these specific changes now? The first thing is that C-12 is clearly an attempt to placate the Trump administration because Trump's original justification for tariffs against Canada was border security, specifically including so-called illegal immigration. So C-12 is like piling on top of the $1.3 billion investment into border security already announced by Trudeau a year ago. And both Trudeau's announcement and Bill C-12 use language explicitly framed in response to Trump's complaints about Canada not pulling its weight in terms of border security. I think the challenge here is that it's unclear if the policy will actually appease the US government. And second, due to this economic and sovereignty threats that have been posed by the US, the Canadian public may currently be willing to stomach more constraints on their personal freedoms and deprioritize humanitarian ideals than they would have without those threats. So I think that's part of the context of why this bill is seen as being able to pass through under a Liberal government. So this leads to point number 2, which is the government's political and economic fear of escalating refugee claimants in Canada. This is a very huge topic, so I'm just going to skim the surface. But key to keep in mind is that the government is responding to the potential of increased claims from both inside Canada and from those in the US. So whether those fears are founded or not is a different kind of question, but I'm just going to try to show why, what numbers the federal government is looking at behind this bill. So this chart is from Stats Canada. It shows refugee claimants, protected persons, and related groups, and includes those who received a negative decision or withdrew or abandoned their claim and have not yet regularized their status or departed Canada, to the best of Statistics Canada's knowledge. And this is the number that the Canadian government and probably provincial governments are concerned with. And you can see that it is still going up even since the additional protocol to the STCA was signed in March 2023. As for US politics, this is basically a very simplified visualization of approximately 14 million people that the Trump administration wants to deport, according to their rhetoric. This includes people with both people without legal status. That's about 60%, but it also includes people with temporary protection from deportation, which is about 40%. And if we look at that 40%, we can see that there's a mix of statuses of people who have varying degrees of legal protection and are being targeted for deportation in different ways and to different extents. So this creates a really complex situation because a lot of these groups are people for whom losing their status in the US may be more highly motivated to seek protection than someone without legal status who can more easily potentially return to a different country. Again, very broad generalizations. But many people in this category face serious risk if they were to be forced to leave the United States or deported. But it's really difficult to predict timelines due to lots of legal challenges and lack of clarity about what the status will be for many of these populations. So we can presume that in the context of 3 more years of this very deportation focused US government, Canada is highly motivated to pass a bill that will proactively prevent what they may see as an additional economic or political burden. I think less publicized is this increasing difficulty of obtaining a visa to Canada, which is what many refugee claimants would need to access Canada's claims process at an airport. So the day after the US presidential election, last year, Canada edited its instructions to visa officers on how to issue visas. And the 10-year multiple entry visa that Canada used to issue is no longer the norm since November. And this is where C-12 is just one part of this broader restrictive environment where IRCC wants the power not just to limit visas for certain citizens, but going back to the power to cancel documents, the government also wants to hypothetically cancel visas issued to someone outside of Canada if the political situation deteriorates so that they cannot board a plane and get to an airport in the first place. So Bill C-12 is important, but it's also part of a broader structural effort on the part of the Canadian government. So very quickly, the next issue is Canada's so-called broken refugee determination system. We all know, I think people in this call are very familiar with the fact that there are backlogs that lead to delays against initial screening, long wait times for work permits, cascades of challenges. I'm not going to belabor this point. I just want to very quickly point out that this is the most recent chart showing the breakdown of claims referred, accepted, rejected, etc. thus far this year. It includes all types of cases that are referred to the Refugee Protection Division. I think a key point is that one, the majority are accepted. So the majority are found to be, fulsome claims. And the second is that there are a significant number that are pending. And, in October 2024, the number of pending applications was around 260,000. Most recently, in October 2025, it's around 299,000 pending. So intakes are decreasing, which the government has been stressing, but the finalizations are not budging very much. So the pending number keeps climbing. I think there's a lot of different ways that the government could respond to this backlog, which, we can discuss. But the point here is that Bill C-12 is likely responding to that pending number. So on a related note, a big objective of Bill C-12 is to respond to the federal government's objective of reducing Canada's temporary resident population to 5%. And, this is a screenshot from the 2025-2027 Immigration Levels Plan, which was issued in fall 2024. And it's really significant because you can see in yellow that the plan assumes hundreds of thousands of temporary residents will leave Canada in 2025 and 2026. As we know, permanent residency options have been dramatically limited. Many temporary residents who came to Canada expecting to stay are still looking for a way to remain in Canada. And given the refugee backlogs and the entitlements that a refugee claim offers, making a refugee claim is one possible way for some people to remain in Canada, even though it's extremely, difficult. So if we look at the proportion of temporary residents among Canada's overall population, the lower line here in dark blue is the graph I showed earlier of asylum claimants and related categories. The upper blue line is representing permit holders like work and study permit holders, family members, etc. What you can see is that the permit holder proportion has gone down a little bit, primarily due to lower study permit numbers, but Canada is still over 7% overall, and it wants to get to 5%. So Bill C-12 is trying to address this by ensuring that the blue line on top doesn't move down to the dark blue line on the bottom. I'm not saying this is happening to the degree that the media portrays it, but this is definitely one of the fears that is behind the government's reasoning in the bill, in my interpretation. So this leads us to the topic of public support. I'll just briefly say, because I think, again, most people in this call are probably very familiar with the changing public perceptions about immigration in Canada, starting around 2023, intensifying in 2024, maybe stabilizing now in 2025. It's not just Trump using anti-immigration discourse. We know that Canadian politicians from a range of parties are using similar language. So it is true that attempts to appease the US administration are definitely driving elements of Bill C-12. It's also the federal government in Canada speaking to that portion of Canadian voters who, for various reasons, may support decreased immigration levels and increased border enforcement. So I think we have to take into consideration that it's politics in both countries are currently at play. Okay, so the last section is just going to be talking about some of the potential implications. I'm going to discuss three. I think it can be heavy because it could be very difficult, but I think it's really good for us to go into this with clear eyes and really think about what could happen and to really prepare ourselves for what this might mean for the sector. So the first implication is shifting backlogs. And this has a wide range of implications. So basically, we can predict that there's going to be a decrease of cases at the IRB and an increase at IRCC of PRRA applications. So remember that a PRRA is submitted to an employee of IRCC as opposed to an IRB, which is submitted to a member and has like a quasi-independent role. So IRCC is currently trying to automate and use like quasi, machine learning and artificial intelligence, but basically automation as much as possible to process its applications because they have such a large backlog of applications across the department. So I think there's real questions about how IRCC would handle such a potentially large number of PRA applications and what that might look like in a department that's currently cutting staff and reducing its budget. The second is an increase in CBSA removal orders that we could potentially anticipate. And the third is an increase in federal court applications for stays of removal from failed PRA applicants while the judicial review is being processed. Federal court, Katie can probably speak to this more more eloquently than I can, but it's basically a very long time and lots of backlogs. And this is, having a lot of implications, not just in this regard, but for many administrative processes. And there's been some analysis done from an academic perspective to say that Bill C-12 is likely to increase overall the efficiency or decrease the efficiency, make the backlogs worse if you take a broad approach. The second is shifting statuses that will impact settlement provision. So we're likely to see an increased number of people with precarious and irregular status. I think some of you at your organizations may already be seeing this. So this includes people waiting to apply for PRA, waiting for the CBSA to give them the opportunity to apply for PRA, as well as PRA applicants, people in Canada with an unenforceable removal order, people with irregular status. So there may be an increased incentive to cross and remain undetected and potentially not apply for anything because approval rates may be so low in certain areas. So, this will impact who is eligible for what kind of government funded services and potentially how organizations will be interacting with their clients. These are predictions. I'm not sure, but this is what I would say. And then finally, how will this impact newcomer needs, client needs? I think if Bill C-12 passes, first, newcomers will likely need more support navigating the legal system, especially increased access to legal aid, and also, what kind of documents and entitlements are they eligible for when along that pathway. Probably not surprisingly, we can anticipate that stress and anxiety may rise because of this added uncertainty, and it can weaken trust in the immigration process overall for clients. I mentioned earlier about information sharing. I think this may impact some privacy and safety concerns and could cause some people to avoid services potentially or feel unsafe disclosing details to service providers, potentially, depending on how that expanded power might be used by the government. A lot of this is still unknown because the bill leaves a lot of the details out, so we don't exactly know how the government is planning to use that expanded power, but there's a wide range of potential uses. And then, of course, all of this will create this need for coordinated policy advocacy to protect access, rights, and safety. So I know that was a lot. However, we have Katie here, which is great because I'm handing it over to her to discuss where we can direct clients for legal support. What are the options right now? And I'm sure there will be continued conversations about Bill C-12 if and when it does pass. So more of these details will be shared. So thank you.
Great. Thank you so much, Lisa. That was really, really enlightening. As I see how this works, kind kind of on the front lines, but it's really interesting to see the policy side and how we got here. My page for claimant resources is quite short, but the I think best place for people who are looking to cross the border or who have crossed and fall under the Safe Third Country Agreement is the Canada-US Border Rights Clinic. Like this is their bread and butter. This is what they do. They don't provide full legal representation for clients, but they do summary advice and provide on occasion some limited scope retainer services, and their website alone is so helpful. This is an area of law that not many lawyers are familiar with or are super comfortable with, just because it's so nuanced and so finicky and as Lisa highlighted in her presentation, like potentially going to change like any minute now. But I would highly recommend sending clients to the Canada-US Border Rights Clinic. And then if you have any clients who are in BC, like we are at the Immigration and Refugee Legal Clinic, are also happy to provide summary legal advice. These can be difficult situations because if someone crosses the border and is making their claim at the border and is immediately turned away, they may not have much time to reach out for legal support. So if there are situations where you have someone who is kind of urgently looking for legal assistance, you would probably be best served by sending them to the Canada-US Border Rights Clinic website so they can get an idea of what the process is, what's going on. Because unfortunately, both us at the IRLC and the Canada-US Border Rights Clinic are quite swamped and may not be able to meet with people in a timely manner. But those are my two big recommendations for legal support. And then for updates, the Canadian Council for Refugees has been really good at providing updates and providing insight on what is going on with the Safe Third Country Agreement. They were involved in the appeal at the Federal Court of Appeal, Supreme Court of Canada. So they are very heavily invested in what's happening and have been my go-to for updates. And then checking out the Government of Canada website can also be helpful, because I'm sure when something passes, it will be a big deal that they'll be bragging about and will be on their newsroom page. But yeah, I think that's everything.
Thank you so much, Katie and Lisa, for kind of unraveling this topic that can be quite complicated and hard to understand. And, even for, those in the settlement sector, but definitely more so for refugee claimants. So unraveling all of that today has been really helpful. And of course, everyone that's joining us, as always, thank you for your dedication to supporting refugees and refugee claimants in British Columbia and beyond, for those joining us from other parts of Canada. Yeah, the work you do is very important. And thank you for joining us today. Big thank you to the province of British Columbia for your support and funding the BC Refugee Hub and the BC Safe Haven program. Thank you, everyone. Have a good afternoon. And thank you again for joining us. And big thank you to Kieran and Con, of course. Thank you so much.